The Appellate Division, First Department is now in session. Good afternoon. People versus Kelvy Acosta is submitted. Bonem versus William Penn. Mr. Mead for appellant. You've been granted 5 and 2. Mr. Mead?
He's muted.
Yes, Your Honor. I'm sorry, had it muted. 5 and 2.
Not a problem. Good afternoon. 5 and 2.
Good afternoon.
And Mr. Schwartz, Mr. Schwartz,
Yes,
you've
I'm
been
here.
granted 6 minutes. Good afternoon.
Good afternoon. Good afternoon, Your Honors.
Durwood versus Daniel R. is submitted. Diamond versus Diamond. Mr. Dowell for appellant. You've
Good
been granted
afternoon.
5 and 2.
Thank you, Your Honor.
And I understand we have a pro hoc vici application. Mr. Schlein, I will hear you.
Yes, Your Honor. Thank you very much. I move this court to grant pro hoc vice status for this appeal to Mr. Matthew Blame, a partner in a law firm, Davison, Eastman, Eunice, and Payone in New Jersey. He is also admitted to the practice of law in Pennsylvania, has argued this case before the Bronx Supreme Court with pro hoc vice status. And I move this court to grant him such status in this appeal.
That application is granted. Mr. Blaine, welcome, and you've been granted 4 minutes.
Thank you, Your Honor.
You're welcome. MTGLQ Investors versus Shea. Mr. Filosa for the appellant.
Yeah, good afternoon, Your Honors.
Good afternoon. You've been granted 5 minutes and the respondents did not request time. Thank you.
Thank you, Your Honors.
People v. Jamel Santiago. Mr. Bertrand.
Yes, Your Honor. Good afternoon.
Good afternoon. You've been granted 4 and 1.
Thank you.
Ms. Chariot.
Yes, Your Honor.
Good afternoon. You've been granted
afternoon.
4 minutes.
Thank you.
Karen's Shipping versus Westside Foods. That matter has been settled.
Yes, Your Honor. This is Ryan Sestak for the appellant. My understanding was that in order to request an adjournment, we had to appear in person. So that would be by phone or video today. And then I was told before that once a case is calendared, an adjournment is not possible. So that we would get a time within which we could withdraw the appeal. And if it's not withdrawn, then I suppose that the appeal would be submitted on the papers.
Yes, that's precisely right. Our understanding was that the matter was settled, though. Am I correct? And that it needs to be reduced to writing?
Exactly. We need to finalize the paperwork.
Okay. Let's make sure that that doesn't take another 6 months. Okay, counsel?
Absolutely, Your Honor.
Thank you so much. You have a happy holiday.
Thank you. Just
Anderson,
one question for clarification.
Can you please do that through the clerk's, sir? I'm trying to pull a calendar. Ask your questions to the clerk's office.
Absolutely. Thank you.
Thank you. Anderson versus Verizon New York is submitted. Tower Insurance versus Johnson. This case is being marked off calendar as stayed due to death of a party. Raymond versus Nefertiti is submitted. Pinkard versus NYC DOE is submitted. Holistic Resources versus Del Valle.
Erica Dubno for the petitioners.
Good afternoon, Ms. Dubno. You've been granted 6 and 2.
Thank you, Your Honor.
Ms. Jerome.
Good afternoon. This is Eva Jerome for the respondents.
Good afternoon, Ms. Jerome. You've been granted 6 minutes.
Thank you.
People v. Justin Morales is submitted. Troy versus Fagelman is submitted. Tren versus Gate of Heaven is submitted. People v. James Thomas. Alexandra Mitter.
Yes, good afternoon, Your Honor.
Good afternoon. You've been granted 4 and 1.
Thank you.
Mr. Myers.
Yes, Your Honor.
Good afternoon. You've been granted
Good
4
afternoon.
minutes, sir.
Thank you.
Villani versus Kings Harbor. Appellant Kings Harbor.
Present, Your Honor. Good afternoon.
Good afternoon. You've been granted 7 and 2. Mr. Bloom for Einstein Hospital.
Yes, good afternoon, Your Honor.
Good afternoon. You've been granted 7 and 2 as well.
Thank you.
And Mr. Horn for the plaintiff.
Good afternoon, Your Honor.
Good afternoon. You've been granted 8 minutes.
Thank you, Your Honor.
Jarmuth versus Wagner is submitted. Gottsman Company versus AEU Inc. is submitted. City of New York versus Siemens Electrical is submitted. Napolitano versus Gustafson is submitted. First case on the calendar, Bonem versus William Penn.
Good afternoon, Your Honor. Robert Mead for William Penn, the appellant.
Good afternoon. Sir, could you raise your voice a little so that we can all hear you?
Yes, Your Honor. I will certainly try.
Please, get a little closer or amplify a little better. Go ahead.
Is that better?
Yes.
Okay. Your Honor, this is an action on a life insurance policy that was in force for 16 years based upon a policy year of January 14th of one year to January 13th of the next year. In 2018, the premium bill for the premium for the next policy year, which began on January 14th, was timely sent to the insured, whose name was
Counselor,
Mike.
Judge Singh, how do you respond to the plaintiff's arguments that you have the wrong date here, that the date should be the 31st, not the 14th?
I'm sorry, is that a question to me?
Yes, sir.
Oh, I'm sorry, I didn't hear the beginning of it.
So how do you respond to the plaintiff's argument that
Right.
January 14th is not the trigger date?
Right. Your Honor, the policy has a specific provision for policy date, which was to be the date from which policy years were computed. That was specified to be January 14th of 2002, which would be the first policy year to January 14th to January 13th of 2003. That was
When did the policy become enforceable?
in the first year. The premium was paid on January 29th of 2002, and pursuant to the terms of the policy, that premium was due on January 14th, which was the date of issue. This is a standard way that life insurance administration, if I could use the word, is done. And when that was paid on January 14th, it went into effect for the first policy year, which was January 14th of 2002 to January 13th of 2003.
So, Mr. Mead, hi, this is Judge Kapnick. So you're saying the fact that the payment wasn't made until approximately 2 weeks after that date had no effect on the due date. That's just how the policies are set up. They entered into the policy and they had a little extra time to make that first payment.
Right. Yes. You know, if you look at the decision in the Katz case, which we cite several times on a brief by Justice Joseph Sullivan of this court, the issue in that case was whether the insured could recover whatever he paid for. I think it was 22 days in the first policy year, and the court decided that he could not. But Justice Sullivan pointed out, and I think the Court of Appeals did also, that these are just first-year issues. The dates for subsequent policy years are determined by the dates that are agreed to in the particular policy, not by when the first year premium happens to be paid. There's always going to be that gap in the first year. And what was done here by Justice Ngoran, he just said, look, it was paid on the 29th. Everything runs from the 29th. It doesn't matter what the policy says. I mean, that's not what this court has said in the Katz case and the Goldman case, and I think there were several others, and all of those cases were later affirmed by the Court of Appeals, emphasizing that these are just first-year issues. They have nothing to do with when subsequent policy years begin and end. And Justice Engoron changed the policy date from January 14th to January 29th for every policy year. And there's absolutely no basis for that at all.
Thank you so much. You will have 2 minutes on rebuttal.
Thank you.
Mr. Schwartz?
Good afternoon. May it please the court. Evan Schwartz. Nice to see you all. Welcome to my kitchen. So let me just correct a few things that counsel started with. First of all, the premium and the effective date of the policy were the same date. It was January 31st, 2001. And the policy clearly did not take effect by the plain language contained in the policy as we.
But counsel, your adversary's position, which seems to be supported by case law, is that we look to the policy terms, and the policy terms specifically says date of issue 01/14. Isn't that the date that governs? And the cases that were referenced, isn't that what they essentially hold? I understand they're under a different posture, but isn't that what they hold?
No, Your Honor. Those cases were for purposes of determining whether or not how much money was being paid for premium, whether they could get some back, but they did not.
But Mr. Schwartz,
yeah.
But Mr. Schwartz, didn't they, so for instance, in the Katz case, weren't they construing the same policy language that we are involved with here, which is the issue about the distinction between an initial premium and an issue date or an anniversary date and the payment of subsequent premiums? Aren't those identical issues?
Actually, while the issues may seem identical, if you look at what we put in our brief at point 5, we actually located and put in the record the policies themselves, and the language contained in those policies differs substantially from the language contained in the William Penn policy. And the language in those policies for purposes of determining lapse and race, which were not the issues in Gold or Katz, the language lines up where the specificity of when premiums are due lines up with what's contained on the schedule page, and that's what actually the policy said. So, for example, in Goldman, they say that the policy date is the date contained on the schedule page. So the date the premiums are actually due is specified both in the Katz and Goldman policies in a clear manner. In this case, the only place where premiums are defined expressly within both the definition section of the policy and in the premium payment section of the policy is date of issue. And there is no other corresponding place, either in the schedule of benefits, that defines what date of issue is. It's expressly defined in this policy.
Mr. Schwartz, did you provide a, based on your argument then, in any successive year of this policy, since the first one, according to you, started on January 29th, the date that the premium was paid, on the subsequent years of renewal, did those renewal policies reflect the January 29th date? Or did they indeed again refer to the original contract date of January 14th?
There is a section in the record that is an administrative section that was.
This is a simple question. Did the renewal policies have a different date?
I'm sorry, did what policies have a different date?
Did the renewal policies of this, the renewals on this policy from year to year, did they change the date to the effective date you're saying?
No, the renewal, nothing happened on they just sent out premium notices and the premiums were paid, but there's no specific evidence of when there would have been a lapse or not a lapse. There's just a reconciliation of premium paid in the record, but it doesn't.
So, Mr. Schwartz,
they sent out an invoice and premiums were paid.
Are you saying that this policy does not specifically indicate that the premium due date is January 14th? I thought I saw that it did.
No, there's words on the schedule page that use the phrase premium due date, but it's not a defined term. And when you look at the actual contract itself, the express terms of the contract say that the date of issue is defined as when the due date for the first premium is a defined term. It's the date of issue. It's a defined term in the policy. So the premium payment section of the policy says the due date for the first premium is the date of issue, the defined term. The first premium must be paid to the agent, and the due date for each premium after the first day is the day after the end of the period for which the previous premium was paid. That is the only place in this policy where there is a defined term, which is date of issue in the definition section, and then in premiums it tells the insured when the premiums need to be paid. So yes, there are portions of the schedule page that have a different date on them. They're not defined terms. This is telling you after you make the first payment, which was made by the insured on January 1st, 2001, each premium is due 31 days thereafter.
Counsel, this is Judge States. What is the expiration date of this policy?
I believe it was a 20-year level term.
Wasn't the expiration date 01443? So isn't that consistent with the date of issue being January 14th?
Well, again, you're referring to what's contained on the schedule page versus what's contained in the actual policy definitions. And they're not consistent, which is why.
Okay, we've heard your argument. I think we've got it. Your time is up. Thank you so much. Mr. Meade, you have 2 minutes.
Yes, Your Honor, if I could just say, I accidentally lost the picture for about 2 minutes, so.
Yes, I saw that. We admitted you back in. You have 2 minutes.
I'm sorry. Yeah, that's what Mr. Schwartz just said about policy date not being a defined term is not correct. On page 29, the policy defines policy date. It said it's shown on the schedule and is the date on which the contract goes into effect. Contract years and anniversaries will be determined from the policy date. The policy date was 1/14/2002. So that I think is a complete answer to what he's claiming, and that
so when you Mr. Meade, this is Judge Mendez. When you look at the schedule, which is page 26 on the record, it has issue date, policy date, expiration date. And they list 1/14/02 as the issue date, 1/14/02 as the policy date, and it says the expiration date is 1/14/2043.
Yes.
You're saying that that's consistent with what's on page 29 on the record regarding the expiration date, the date of issue, and the policy date.
Yes, and it's also consistent with, I think, what's on the premium payment section on page 30. I mean, everything here is based upon January 14th. If I could just point out, the reason why there's a date of issue and a policy date is because of a concept known as backdating to save age. Some people can save money by paying for up to 6 months before the effective date when they don't have coverage, but to run the policy date from back there. So in those kind of situations, the date of issue would stay current, but the policy date would be 6 months early. So that's why here, I mean, all the dates are the same, but they're not always. And they're not necessarily the same.
Thank you so much.
Okay, thank you. Good afternoon, Your Honor.
Good afternoon.
Thank you.
Diamond versus Diamond, Mr. Dowell. Mr. Dowell.
Yes, good afternoon, Your Honor.
Good afternoon.
This appeal asks this court to reverse the IAS court's decision to the extent that it vacated in part the reasoned award of the arbitration panel. Reversal is necessary because the IAS court was misled as to the nature of appellant's claims in the arbitration and what transpired at the arbitration hearing. And this in turn led the IAS court to misapply New York law, holding that arbitration awards are largely unreviewable and that arbitrators' discretion with respect to fashioning appropriate remedies to fit the facts adduced at trial is almost functionally unlimited.
So, Mr. Dowell, wasn't one of the issues that that they raised, the respondent raised, or the other side raised in before the trial court, the motion court, was that it wasn't clear in the original demand that they were looking for, that your client was looking for a possibility of damages and just not a reinstatement of that interest that he had previously. And wasn't that a big part of his argument? And did you make that clear in the arbitration demand, but that was one of the things that you wanted, or did that sort of come along later?
That was certainly a focus of their argument. And what's important for the analysis under New York law is that the claims at issue were for misappropriation and conversion. Those were clearly set forth in the arbitration demand. There is no explicit reference to monetary damages set forth in the demand, but the demand did seek generally such other relief as was just and proper. And what New York law makes clear, and it's the most critical issue on this appeal, that so long as the claims are litigated at the hearing and subject to cross-examination, that the remedy flowing from those claims upon a finding of liability is within the complete discretion of the arbitrator. And there's no dispute here that the claims were for misappropriation and conversion, that those claims were fully litigated, and thus that this dispute is not about a claim, it's just about the remedy. And this court and the Court of Appeals have been very clear in stating that remedial discretion lies with the arbitrator and is not subject to second guessing by the IAS court. So the underlying claim was for forgery, and the arbitration hearing was before 3 arbitrators. The arbitration lasted 5 or 6 days. They admitted 350 documents into evidence. We heard testimony from 11 witnesses. The award that followed was 10 single-spaced pages, wherein the panel found that the evidence of forgery and theft was overwhelming. And then you get to page 60 of the record, which is the damages section in the award, and the arbitrators exercising their wide discretion under the parties' agreement and the arbitration clause and Rule 47A of the AAA commercial rules, which this court has cited and the Court of Appeals has cited, elected monetary damages as the remedy, and they explained why. And the 2 central arguments that respondent has raised both before the IAS court and on this appeal is, one, that they did not receive adequate notice that monetary damages would be in play. They mislabel it as a buyout claim, but this case was never about a buyout claim. What this fight is about the remedy. And this court in Frankel v. Sardis in 2010, and then just last year in Chef Chloe v. Wasser, made clear that if all we're talking about is a remedy, then that's within the province of the arbitrators. The IAS court ignored that law, which is dispositive on this appeal. They ignored Rule 47A, which this court has cited with approval. And there's no dispute here that the arbitration clause was broad and that the claims in this case, which were for misappropriation and conversion, were the subject of discovery and fully litigated at the hearing. So in terms of begging the question of how the IAS court got it wrong, it was this mislabeling exercise.
Why don't we discuss that on your rebuttal time?
Thank you.
Okay. All right, Mr. Blaine, you have 4 minutes.
Yes, good afternoon. And I just want to clarify that I would agree with every point that Mr. Dowell's making if we actually had an opportunity to present evidence on what the fair market value of the 21% interest was.
I'm sorry, Counselor, this is Judge Singh. Didn't your client have a full and fair opportunity to issue the to litigate the issues with respect to whether or not that agreement was a forgery. And it's my recollection that your client was not even able to come up with an original document.
That's correct, Your Honor, and that's not the reason why we have sought to vacate this arbitration award, the component of the award dealing with the buyout claim.
So, but my question is, didn't your client get a full and fair opportunity to litigate these issues before the panel over the 5 or 6 days of the hearings?
No, Your Honor, my client did not have an opportunity to litigate these issues. There was never any damages that were sought in relation to the 21% interest. There was never a quantification of those damages.
There was a quantification in the demand for arbitration at $2.5 million. What was that attributable to?
That was attributable to 2 other claims that are addressed in our respondent's brief. That was for.
But those claims never added up to $2.5 million.
They did, Your Honor. There was
best?
890,000 and about I think it was 1.6 million. Were the other amount. So that's how it got to the 2.5 million. And the demand clearly specifies that there's no relief in relation to the 21% aside from an accounting and a reinstatement of that interest. So
but Mr. Blaine, didn't the court, didn't the arbitrators consider the amounts that had been offered to other parties right before and right after this happened and made a value judgment that way that can't just be thrown out and discounted?
Well, I mean, Judge, they did, but that had absolutely nothing to do with this claim. And I just want to make sure that this is.
Of course, it has something to do with this claim. It's the same company, the same interest, different percentage numbers, and 2 parties receive a certain amount for their shares. And this, on the 21% of this party's shares, there's a different calculation, smack in the middle. Of course,
Honor,
it has everything to do with it.
Your Honor, it does not, and I just want to clarify. First, the one of the purchases that the respondent was seeking to unwind, where the $110,000 a membership point was referenced, was the purchase of my client's 25% interest. That was paid over 10 years. That's a 10-year promissory note. And we were not able to present any evidence as to how that 10-year promissory note, how essentially that $110,000 paid over 10 years should be discounted to the present value if there's going to be a damages award, because we didn't have knowledge that there was a damages award in relation to this 21%. There is also the issue of this $521,000 loan account that was awarded. That's not money that ever benefited my client. My client hasn't received the $521,000. It's essentially an illusory damages award. If we knew that there was a possibility that there was a $521,000 damage request in relation to this claim, then we would have presented more evidence. We would have presented evidence about this $521,000 never being paid to my client. It still hasn't been paid to my client today. So with this defective notice, it's impossible for us to establish our claim. We also have the fact that the respondent refused to provide us with any discovery concerning damages in their discovery demand, in the responses to the discovery demands, and that's set forth in the record at R166, R179, and then R181.
I'm going to give you one more minute. I'm going to give you one more minute because you're over time. I believe my colleague has a question.
I'm sorry.
Go ahead.
I'll be very quick. I just want to go back to the fact that the arbitrator made reference to Rule 47A of the commercial rules of the association, as Mr. Dowell referenced. And how do you discount that? The arbitrator may grant any remedy or relief that the arbitrator deems just and equitable and within the scope of the agreement of the parties. It's pretty broad. How do you get past that?
We didn't know that this was actually a buyout claim until 2 months after the evidentiary hearings closed.
This isn't a buyout claim. Buyout means that the parties sat down and talked about what the value of my shares are and what you're willing to pay for it. These shares were just taken.
No, I'm talking about a buyout claim as though you're valuing a 21% interest, because that's essentially what the claimant is saying, that we knew about this all along. We didn't know that this was about the value of a 21% interest. If I knew that this was the value of a 21% interest, there would have been experts that would have been obtained. There would have been capital gains issues that are addressed. There would have been minority discounts that are addressed.
Could you refresh my recollection? What did your client get for the sale of Scott's 21% interest?
He received a promissory note that was paid out over a I believe it was a 5 or 10-year time period. And
So
there was one
wasn't
payment
getting
of $400,000.
$70,000 a point?
That's correct.
Was he getting $70,000 a point?
Yes, it was
And
$70,000.
So wasn't the value, the fair market value, closer to 2 million plus?
It depends on what you consider the value of a minority interest after the person that was purchasing the other interests obtained the majority. Essentially, the sale of the 21% happened after Mr. Forescu obtained 51% of interest in the company otherwise. So you get to the issue of a minority discount that would apply there, which is the reason why there was only a sale for $70,000 a point as opposed to $110,000 a point. And because of the way that this procedure went, we were completely unable to develop this information and this evidence at hearing. There is a question.
Thank you. Sir, you're out of time. Thank you. Mr. Dowell, you have 2 minutes.
Thank you, Your Honor. These references to fair market value, to present value, to minority discount, it's as if we're talking in an alternative universe about an arm's length negotiation concerning the purchase of a minority interest. That's not what this case was about. It was a very fraught dispute between father and son, where the panel found that the father used a forged document to steal an interest and sell it to Mr. Forescu. And now what we're hearing is that expert evidence was necessary to knock down the value of the asset that his client would deem to have stolen. It's an absurd proposition. The evidence that the arbitration panel actually relied on was out in discovery, and it was front and center in the arbitration. It related, the market for this asset was simple. There was one buyer, it was Mr. Forescu, and in 2016, he offered every other member $110,000 per point. And that's what the panel cited on record page 60 in the damages section of its award. And then critically, if we're talking about this issue that by the time my client's interest was sold, he had been reduced to a minority interest, Mr. Forescu confirmed that even after he had achieved majority status, he still offered another member, David Brown, $110,000 per point. And that's not me saying it. That's the evidence that the panel relied on in explaining that this calculation was straightforward and yielded a result that was certain and that no further evidence was needed. These arguments we're hearing about late notice and the panel's finding of evidentiary sufficiency, those were already addressed by the panel and they were rejected. And that's what matters under New York law.
Thank you. Thank you so much.
Thank you.
NTGLQ Investors, Mr. Filosa, you have 5 minutes.
Good afternoon, Your Honors. May it please the court. The order and judgment of the Supreme Court should be reversed. Appellant is the successor in interest here in this foreclosure action to two defendants, Defendant Meldow and Defendant Eaton. Both Ms. Meldow and Ms. Eaton were the former owners of the mortgage premises. So as the successor in interest, appellant stands in the shoes. Each defendant, Ms. Meldow and Ms. Eaton, had a distinct defense, had distinct defenses, which the appellant could and did raise as a successor in interest to these defendants before the Supreme Court. Now, the Supreme Court acknowledged that the appellant had standing as a successor in interest and arguably as a successor under 1018 as an interested party under CPLR 5515 to raise these defenses, but essentially the Supreme Court determined that it wasn't going to address the merits because it essentially would be inequitable or unfair to dismiss this foreclosure action as against the bank. So essentially just viewing it from the prism of equity or fairness, where the grounds we moved under, say for instance, for Ms. Meldow, was lack of personal jurisdiction. Ms. Meldow was...
Let me just, this is Judge Gates, let me just step you back a little bit. You step into the shoes of the debtors here. There was also a notice of pendency that had been filed, correct?
Correct.
So you you step into their shoes as they would be at the time you otherwise acquired title, correct?
Correct.
So in other words, we don't go back to square zero. We can only take the matter forward, right? You with me so far? Wait, let me
Correct.
ask my questions.
Certainly.
I think you'll ultimately agree with me. By the time you stepped in, there had already been an order of reference on default, correct?
Correct.
So your right here really was to come in and you could stand in the shoes of the debtor and you could move on any grounds that the debtor would have had to vacate the default, not necessarily to undo everything in this action, although personal jurisdiction, if you were right on, would undo everything.
I agree with Your Honor, but insofar as the position that a purchaser takes subject to a notice of pendency, that we agree with, but that doesn't preclude the successor, again, from defending the case from that point forward. Now, Your Honor made reference.
From that point forward, I think we're agreed. So
Correct.
in other words, you couldn't come in and put an answer like it was just the beginning of the foreclosure action.
Of course, we continue the case at the juncture in which we took title, but so.
And at the juncture you took, there was an order of reference on default.
Correct. But that doesn't. But an order of reference, again, which was rendered on default, presupposes that personal jurisdiction was obtained over Miss
So I don't
Meldau
think we're
and Miss Eaton.
disagreeing about, did you have the right at that time to make a motion to vacate the default because the court had never acquired jurisdiction over one of the debtors?
Excuse me, Your Honor?
Did you have the right to seek to vacate the default on the order of reference, or the default generally, because the court had not acquired jurisdiction?
Yes, that is at no time waived. Lack of personal jurisdiction is at no time waived. This court is the Appellate Division has recognized it. Say, for instance, in Chan v. Onyx, it's 156 Appellate Division 3rd, 1361, where a successor in interest moves on lack of personal jurisdiction grounds successfully for the Supreme Court's failure to obtain personal jurisdiction over the predecessor. Another example of that in the Appellate Division, Bello v. Lozer.
I think we've got it, counsel.
Yeah.
So
have a great afternoon.
Thank
We've
you.
got it. Okay. People v. Jamel Santiago.
Good afternoon, Your Honor. It's David Bertan.
Bertan, you have 4 minutes.
Thank you, Your Honor. The question before the court really comes down to how is a DWI arrest admissible or relevant in an unrelated 4-month prior accident case? What you have here is just an attempt to sort of bootstrap the DWI arrest into the accident case to get the jury to think, well, if Mr. Santiago had been drinking in January, he might have been drinking at the time of the incident here. There is...
Counselor, would it be fair, or you'd say it's unfair to say it was harmless error?
No, it's not harmless. Thank you for making that clear for me, Your Honor. No, it is not in any way harmless error. The prejudice here was allowing the jury to think drinking here, drinking there. And there was no reason for it. Officer Milligan's identification of the defendant at the toll plaza is something that the jury really should have heard on their own. They could look at a photo from the toll plaza. These pictures were available to the investigating detectives within days.
Was there any argument that the quality of those toll plaza photographs were of poor quality, blurry, such that additional evidence was required? Was there any such statements on the record about that?
No, Your Honor. And Officer Milligan seemed to be able to make his erroneous, I wouldn't say erroneous, he wasn't wrong, but his incorrect identification, this inadmissible identification based on those photos. It would have been very simple for the detectives, when I say detectives, the accident detectives, to simply pull Mr. Santiago's DMV photo or go through the registration and go speak to Mr. Santiago. He's lived in Yonkers almost his entire life.
Well, did the photograph at the toll booth, the photograph, his appearance at the time of his arrest, look different in any significant way such that additional evidence would have been required?
Your Honor, there's no indication that that's the case, but if that were the case, it would have been very simple for the people to take his arrest photo from the DWI case, redact it so that it did not show any other information, and show that to the jury.
But that argument asserted, is what I'm.
That was not asserted below, Your Honor, by either side.
Okay, all right.
It's, if that's the court's questions, I will wait for my 1 minute of rebuttal.
Okay.
Thank you, Your Honor.
Ms. Dubno, you're up. You got 4 minutes.
Yeah.
I'm sorry, Your Honor, I don't believe this is my case.
Oh, I'm sorry. I'm looking at the wrong.
I could try, but I don't think it would be in the kind of best interest.
I have no objection to that.
I'm sorry, Miss Chariot.
May it please the court, Julia
My
Chariot.
apologies, Miss Chariot. I'm looking at a chart and there's lines all over the place. Please proceed.
Thank you. May it please the court. Your Honor, the record is very clear that the two incidents were completely separated. They were presented separately. They were easily segregable.
So my question is, if they're so separate, why do one trial presenting these two very separate incidents to one jury?
Well, they're segregable to the point that it's not going to cause any confusion to the jury, and the jury could keep them separate. I'm sorry?
What if it did?
Confusion is not my concern. It's the prejudice.
Yeah.
Well, but the point is that the fact of the matter is the arrest from the accident case came about as a result of the identification made that was part of the Dewey arrest. Officer Milligan was able to.
But you didn't need counsel. That wasn't required in order to make this arrest. You could have, as counsel pointed out, gone to the toll booth tapes. This was an accident that happened at 3:26 in the morning. So we're not talking about excessive traffic, right?
No,
so we would have been able to go to the tapes from the toll booth and ascertain which of the black dark vehicles came after the witness's car. This was not hard. And it's exactly what you did. So why the extra separate, potentially prejudicial evidence of a Dewey arrest that had nothing to do with this case?
Well, Your Honor, yes, that is what we did. It took a lot of time to get the records. I mean, we can in the abstract say they could have just done this and that. They made all the requests, but it did take time for all the materials to come in, the review to be done. And at a certain point, they had the photo and they had the idea of the car being registered to the defendant, but they didn't have the link. He got arrested on the Dewey before any steps were taken to make the link. Could there have been theoretically another way? Possibly, but this is how it was done. It remained allowable. It was a permissible joinder because, you can't just say, oh, without looking at the photos, there's no way to be certain that a jury could have done years after the fact, looked at a photo of unknown quality to us right now and immediately identified the defendant versus Officer Milligan, who spent hours with the
Counselor, but these crimes were totally unrelated, other than the fact that one was used to identify him in the earlier one, right?
Yes, they were. Yeah, other than the fact that the relation of the second case was about the identification and Officer Milligan's ability to make it.
Right. So again, the question is, why did they have to be tried together? If your only issue is identification, couldn't there be like limited testimony from Officer Mulligan that wouldn't have been or put in the juror's mind that this man had some history or propensity for drunk driving, which might impact on the first case?
We can't change the facts of how the arrest was made. The two lower courts reviewed
it.
They made the determination.
You can limit it to identification information. You don't have to try the cases together in order to elicit appropriate redacted information in the investigation of the second case. The judge would have helped you craft it to otherwise deal with your issue of identification.
two lower trial courts reviewed it and found them properly joined.
And that
Counsel,
is
that's
why
why
it's
we're
up
here.
here.
They were,
I mean, I have
And that is
Your Honor,
why
if
it's up
I
here.
may speak
And
to
that is
prejudice.
why, you know, we're talking about this. This is a crucial issue to us.
If I may,
Let's assume for a minute that they shouldn't have been joined. Can you discuss the issue of harmless error? Was there any prejudice?
if I may discuss that. To the extent that, you know, there's this contention that the jury would have automatically assumed that he was drinking under the first incident because of the low-level intoxication from the second DWE case. There's no evidence presented from either the eyewitnesses or the video or the footage from the toll booth or any claim that defendant was acting under the influence of any
Counsel, the
intoxication.
evidence at trial, I can't even believe you made that argument. The evidence at trial is that there are two people on the highway waving their arms to an oncoming vehicle. He does not stop, pause, or anything, and they have to run off the road, and he runs over a body on the road. That's the evidence. So if that doesn't constitute some seriously bad driving, then I don't know what does.
That could have happened, with respect, Your Honor, under other reasons. He could have been tired. It was 3-something in the morning. There was no reason to automatically assume not every single leaving the scene without reporting crime.
Yes,
but
but
there's
problem
evidence
is,
that
Ms. Charia, by trying these cases together, I go back to what Judge Mansonet Daniel said a while ago. How do you get past the prejudice? I mean, by putting these cases together under these circumstances, how can you say this was harmless error? How can you say that the prejudice did not outweigh the probative value of the otherwise outweigh the probative value of the
Okay, then assuming that tailored evidence was admitted as to the identification, I think the outcome is the same. He is still convicted of leaving the scene. You had numerous eyewitnesses testifying as to the color of the car, the conditions of the driving, the damage, the injury was obvious. It was clear from the circumstances that the driver of that Acura had to know that he caused physical injury.
Okay, thank you, ma'am. We've gone way over the time. Thank you. Okay, Mr. Pertan, you're up. I'll give you 2 minutes.
Your Honor, I'll just say really quickly that if the prosecutor is arguing that a photo of unknown quality was the reason why Officer Milligan had to review it, if it's good enough for Officer Milligan to make an identification, then clearly it's good enough for the jury to look at the photo from the toll plaza and the defendant. And again, if they had done it, a redacted arrest photo and say, this is the same person. There was no need to bring Officer Milligan in to talk about a DWI arrest for an accident that occurred at 3-something on a holiday weekend morning. It just clearly raised in the jury's mind the possibility that this man was drinking. Had they not heard about the DWI arrest, that factor would have been out of it. If the court has no further questions for me, Your Honor, I would rest on the brief. Thank you.
Thank you so much. Okay, and now Ms. Dubno on Holistics Resources.
Your Honor, thank you. I welcome that. I feel a little more comfortable talking about this case. As Your Honor recognized and others recognized in the Testwell versus New York City Buildings Department, once somebody receives a license and they have that license to do something work-related, it becomes essential to their livelihood and their ability to work. And as a consequence, the administrative code recognizes that where somebody has a license to sell tobacco products, there is a mandatory revocation of that license if they've had 2 or more underage sales within a 3-year period of time. But there is also a mandatory waiver of that revocation, whereas here there is substantial evidence of, the different factors that are under the statutory provision. And here at the oath hearing, it was established that Mr. Akbar, he's an immigrant. He came to this country. He wants to keep his business. He sponsors a softball team, so he clearly cares about children. He mentioned that he cares about children. He had no interest in selling cigarettes or any tobacco products to underage people. What happened was there were 2 isolated incidents where his employees bypassed all of the security systems that he had put in, and as a result, you had these 2 isolated sales.
Ms. Stubner, weren't they kind of focused a lot at the hearing about the retraining, the monitoring of the employees, and some type of periodic retraining? Wasn't that a focus of theirs, and that wasn't that something that maybe was not shown as well as it might have been shown to the agency?
Certainly, Your Honor, that was not the focus of the original oath hearing officer's decision. He did not address that part at all. That was only raised by the appeals bureau, the appeals unit. But you're correct, that was the basis for the decision. And it's just not the case. If you look through the record, it establishes that that the employees, both employees took the state certification class. That's valid for 3 years. There's actually no basis for giving it to them again because it's valid for 3 years. The testimony was pretty extensive. They said, we had the first employee do the course and do all the training. They said, apart from the training course, this is done by us. I sit with them at the computer. We train them all that. They said the second employee passed all the training systems, plural. They said that there was appropriate training and regular reminders. And they said other checks and systems are also in place, and that he emphasized the policy. There was substantial evidence in the record of retraining. And so it's not a situation where you just have nothing. They take the class and nothing else has gone on. The second employee said, I had reminders, and what happened? She was distracted. What happened was the undercover officer was horsing around. He was riding on the hood of the car in the parking lot with other Department of Consumer Affairs employees. They were distracting her, and yeah, she hit the bypass button. But the reality is that Mr. Akbar, he had put signs up. He put a cash register in that freezes anytime there's any kind of age-restricted product like alcohol or tobacco. He had done all of these different things. He did the training. He sat with the employees during the training. He really, went and, during the hearing, to which, here he was by himself. He didn't have counsel. You're talking about somebody who wasn't being guided through the process. There he is at the hearing. And at one point, the representative from the Department of Consumer Affairs, who is a lawyer, said in her closing argument, Your Honor, there was no evidence that they had one of these cash registers that froze the sale. And Mr. Akbar, who had no idea that he was supposed to even present evidence of this, he said, Your Honor, we do have that. And, it was part of the decision that he does, in fact, have that device in his store. So I think it's pretty established that, all of the evidence was there. I see I have a few minutes left, but
I'll give you your time in rebuttal, okay?
Thank you, Your Honor. I appreciate that.
Ms. Jerome, you have 6 minutes. You're on mute. We can't hear you.
Thank you, Your Honor. Good afternoon.
Good afternoon.
Please the court. Eva Jerome from the New York City Law Department on behalf of respondents. The issue here before the court is whether the Oath Appeals Unit's determination that petitioners failed to meet their burden was irrational or not. If there was a rational basis for the appeals unit to determine that the petitioners failed to meet by preponderance of the evidence that they either monitored the performance in between the 2 illicit sales, they monitored the performance of employees to ensure adherence to a policy of not selling to minors.
Counsel, as I could not help as I reviewed the papers here, it very much felt like this was a litigant that would have tremendously benefited from having counsel present, that an attorney would have been able to elicit the kind of specific information that I think allows your agency to argue there wasn't sufficient evidence on the record. He says things like, we did training and more stuff like that, but he doesn't describe exactly what more stuff like that means. So my question to you is, does the agency, as it goes through these hearings with unrepresented business people, attempt to at least ask the very basic factual questions that the arbitrator knows you need to know in order to make a determination on this?
Your Honor, I
mean, a simple, sir, would you please describe in particular what you mean when you say you sat there and watched them? What are you talking about? Things like that.
Yes, Your Honor. Well, I'll first point out that, of course, this issue, you are concerned about it, but it was only raised in the reply brief for the first time, not even until the reply brief. But to the extent you do want to address it, the ALJ clearly said, we can postpone this hearing and let you get an attorney. And he declined, Mr. Akbar. And let's remember that he totally ignored the first violation. He allowed a default to be entered. It's a privilege to have a tobacco sales license. And with that comes a burden to make sure that you do everything to hold on to that. It's not an entitlement. And once you violate
I understand all that. Can you answer my question? Does the hearing officer attempt to elicit the necessary information to understand whether this business person is indeed trying to comply with the law? I don't think this should be a gotcha kind of process. It should be, if you're a bad businessman and you sell cigarettes to minors, you should lose your license. But if you're not, and you have tried to ameliorate the mistake of one of your employees, I, as an agency, should not try to get you during the hearing because you don't have a lawyer. So again, my question is, does the arbitrator try to elicit the factual questions that are necessary in order to ascertain whether this man and his business is indeed in compliance with the law?
Your Honor, I believe the ALJ is sworn to be a neutral, and the ALJ fulfilled his obligation in this case by warning the business owner, who was a sophisticated party, that he had the right to have an adjournment and to obtain an attorney. It's a very complicated issue, exactly what ALJs are supposed to do beyond that, and it wasn't fully briefed because, of course, it wasn't raised at all until the reply brief. I respectfully submit that this is not properly before the court at this time, or the right case, and to also point out that he's a 7-Eleven business owner. He's not, and he went through a lot of hoops to get the tobacco license. He was told after the first, when he got the summons for the second violation, he was told that revocation of his license that he claims now is valuable, and indeed it probably is. That's the time for a business owner to step up and obtain counsel and fully understand the implications of a second violation. The city council has made clear that strict liability applies, and when the licensee is told in the summons that they risk revocation, that's when you take it seriously if you haven't taken it seriously before. And frankly, they didn't take it seriously before, in that they allowed a default judgment to be entered against them.
Thank you. Thank you so much.
Thank you, Your Honor.
Mr. Bono, you have 2 minutes.
Thank you, Your Honor. A couple of things. As to whether or not the hearing officer, neither the hearing officer nor the representative from the Department of Consumer Affairs gave Mr. Akbar any guidance as to what he needed to establish. And the Mims case from the Second Circuit says that where you have an unrepresented party, that they should be given guidance by the hearing officer as to the specific elements that they need to establish. Relating to whether or not it was only raised for the first time in the reply, just want to say that this is a fundamental proposition there, and it was because the city kept saying, the Department of Consumer Affairs kept saying it was only through snippets that he was able to establish his burden. That's where it sort of underscored the fact that this was an unrepresented party there. As to the fact that he had a default, yes, he did have a default, and his justification for the default was that he wasn't going to deny it. He was doing the honorable thing. He didn't have a defense to it, but then he got the training program. He did all of the different steps afterwards. I mean, the fact that he defaulted on the first violation shouldn't be a basis for penalizing him later on. And the fact that he is a 7-Eleven businessman, he did jump through hoops. He jumped through a lot of hoops to get this license, and he doesn't have it anymore, and it is very essential to him. So if there are no further questions, Your Honor.
Thank you so much. People v. James Thomas, Ms. Mitter.
Good afternoon, and
Good
may it please the
afternoon.
court, Alexandra Mitter for Appellant James Thomas. Mr. Thomas needs mental health services, treatment, his family, not a 17-year sentence. He has struggled with serious mental health issues for his entire adult life, beginning in his mid-teens, but he is rapidly decompensating in the prison environment.
Ms. Mitter, let me ask you a question. I was in reading the briefs, it seems to me that there was a lot of emphasis in this particular case on the effect that this particular criminal activity in 2013 had on the complainant, that he broke down on the stand, he was devastated. I understand that they just took an old cell phone and he eventually got it back, but there was a weapon, and Mr. White said, I saw bullets in the weapon. So, I mean, it seems that this was part of what the judge was very concerned about in this particular case. It was emphasized more than I sometimes see it, the reaction of the complainant.
Yes, I would say the complainant's testimony was more sort of colorful and dramatic on that point than most. And, I didn't grow up here in the 80s, but I can only imagine how scary it must be to be, stuck up on the street. But that being said, while the court spent a lot of time considering the complainant's mental health, it paid no attention to Mr. Thomas's mental health. And in the 3 years of prison.
Well, the second time around, I think they did see that there was a mental health issue once he had been in prison for a while at the resentencing. I think there was more emphasis on that, although the amount didn't change that much.
Yes, we emphasized Mr. Thomas's significant decompensation at the resentencing. And so it was before the court and is obviously therefore properly considered by this court in our appeal.
And this is Judge Gish. And it just to look at this, when the court originally imposed sentence before the first appeal, it was 21 years, but she broke it down and she did 15 years for the count, which is now the top count that existed after the appeal. Right. And we sent it back down for resentencing. And even knowing the mental health history, she resentenced him, but she sentenced him for 17 years. She didn't start from 15 years. Do we have any idea why?
Well, I
started with 15 years. That was the sentence.
I think that would have been a far more appropriate thing to do, and would have been appropriate to go lower from there, because when 15 years was appropriate on that top count, the judge had no idea about the very serious mental health issues Mr. Thomas was suffering at the time. And once that information was before her, that was significant mitigation that really counsels in favor of a far lower sentence than Mr. Thomas ultimately received.
Right. In fact, it seemed that the impetus for her reduction from 21 to 17 were the mental health issues and the fact that he was decompensating in prison.
I think, frankly, the trial court was a bit confused about the basis for the remand. She wasn't quite sure how it all fit together. I tried to explain that this court remanded for resentencing, notwithstanding the prosecutor saying it wasn't necessary to do so because it changed the range of sentences that Mr. Thomas, had available to him. So I think there was some confusion there, and I think as a result, the sentence is too high. Mr. Thomas has gone from the lowest mental health designation over 3 years in prison care to the absolute highest designation, and the Correctional Association has detailed in extensive detail how prison just is ill-equipped to care for people like Mr. Thomas and actively makes it worse.
Did you also indicate in your papers, Ms. Mitter, that he was in some type of a, it's not really solitary confinement, but he was sort of put apart from prison or the regular prison, not because he needed solitary confinement or protection, but because they weren't able to handle his particular mental health issues. Is that correct?
I would say it's worse than solitary confinement, Your Honor. It's the RCTP, is the Residential Crisis Treatment Program, and it's designed for people under crisis observation for 1 to 4 days at most. He's spending months there. You get no property, unlike in normal solitary confinement, and you're in a Velcro smock because they're concerned that you're going to hang yourself with your normal clothing. I mean, it is very, very, very isolating. And, Mr. Thomas's mental health is not surprisingly suffering as a result. He's been in inpatient psychiatric treatment, but there have been times where inpatient psychiatric treatment has been recommended by prison staff, and it's been rejected for whatever reason by the powers that be. So he's just he's not getting the treatment he needs. He's getting worse. And the longer he spends in prison, the worse his mental health is going to be. And it's not just his mental health that's suffering. His physical health is suffering as a result too. He's been hospitalized.
You can tell us about that on rebuttal, okay?
Thank you.
Mr. Myers, the floor is yours.
You're muted.
You're muted.
Sorry about that, Your Honor.
No problem.
We're going to be laughing about this "you're muted" years from now.
Thank you, Your Honors. Robert Myers for the Office of Darcel Clark. Good afternoon, and may it please the court. This court should affirm the judgment of the court below. The court imposed a fair sentence that properly accounted for the grave circumstances of defendant's crime.
Well, let me ask you something on that in that regard. Initially, when there were some negotiations, plea negotiations prior to defendant deciding to go to trial, didn't the judge either agree with the prosecution or suggest that a 7-year term would be appropriate? And nonetheless, after the trial, initially they gave 21 years, reduced only to 17 after the resentencing. So, I mean, how do you, put that all together?
And yes, Your Honor, I first would direct the court to People v. Martinez. Given the bargaining process that goes on in a plea negotiation, naturally a sentence at trial is more severe than a sentence that may be offered.
Triple, Mr. Myers?
And well, I
was offered 7 after trial, triple. So for exercising his constitutional right to go to trial, he should receive triple the amount of time.
Well,
is that what Martinez says?
Well, in Martinez, Your Honor, the Court of Appeals affirmed a sentence of 10 to 20 years incarceration after the prosecutor had offered a non-incarceratory sentence of 10 years probation initially. And I do want to just talk a little bit about the trial. As I'd mentioned before, the court saw the victim break down on the stand. This was a robbery with a loaded gun, and not defendant's first robbery where he threatened the use of a gun as well. The court also heard tapes played in court of phone calls made by defendant from Rikers trying to coerce his family members and friends to push his younger co-defendant to take the fall for him because defendant is very familiar with the criminal justice system based on his multiple convictions and knew that his co-defendant would receive a lesser sentence. The court also saw defendant up close over, again, the 2 weeks of trial and imposed a very fair sentence, imposing less than the maximum requested by the people.
But wasn't it true that, I as I said, I brought up earlier that the victim, the complainant, certainly seemed to be very much affected by this event. But wasn't it also true that originally the sentencing judge at the first time around did not have too much of this mental health information before her to in evaluating the appropriate sentence for the defendant here?
And yes, and I do want to address that. The sentencing court said that it was familiar generally, but certainly not to the detail that went into the 137-page submission that included 9 exhibits that was presented and carefully evaluated at resentencing. In fact, the judge was I don't want to say moved, but the judge took that very seriously to the point that the court ordered a 730 examination at the initial proceeding, despite the fact that defense counsel said defendant gave no reason to think that he was incompetent to proceed. And actually, defendant gave a very eloquent statement regarding the subsection that he was convicted under and stating the subsection he believed he should have been convicted under instead, and stated why he felt that a sentence that was reduced would be more appropriate. The judge actually then said that those sentencing minutes should also be considered, given the fact that they were very eloquent and seemed to very comprehensively articulate his understandings of what was going on and what was taking place.
Counsel, are you I'm not sure what the import of that statement was, because it seems to demonstrate a lack of understanding of mental health. Because the fact that you are intelligent and can understand a legal process doesn't mean that you are not seriously mentally ill. The two are not mutually exclusive. You can be quite eloquent, and quite frankly, geniuses have been found to be mad, and yet they're geniuses. So I'm not sure what that had to do with anything.
And Your Honor, it does not state, and it's not conclusive proof of defendant's mental health. Of course, the proof of defendant's mental health would be carefully evaluated by professionals, which is why the court would have sent him to be evaluated for a 730 exam. 2 mental health professionals evaluated him and unanimously said he was fit to proceed and could proceed.
Again, you're missing my point as well. Being fit to proceed is such a low standard, okay, versus the understanding of the depth of someone's mental health disease. You can be both. You can be very mentally ill and yet be fit to proceed under 730. So the two are not mutually exclusive, is my point. But we've run out of time. I'll give you another 30 seconds to wrap up, though.
And thank you, Your Honor. This court should affirm and reaffirm the decision of the sentencing court, which again had the opportunity to very carefully evaluate defendant both before his incarceration and after his incarceration 4 years later, and impose a fair and proper sentence. Thank you.
Thank you so much, Mr. Myers. Ms. Mitter, you have 2 minutes.
Thank you. Just to briefly clarify the record as to what was before the trial court at the first sentencing. Before the first sentencing, defense counsel noted that Mr. Thomas had an ADHD diagnosis and a quote unquote lifelong depressive state, whatever that may be. The prosecutor then responded that the court should ignore it because it was not documented. And in response, counsel said that he was actually not asking for the court to consider it in asking for a lower sentence than the maximum.
Ms. Mitter, can I confirm, has your client been in prison since 2013? Is that correct?
He has been in prison since his arrest on this case.
Which was right, like the day of the incident.
The day of the incident, that's correct. He was in custody the entire time. And so, for all the reasons discussed in our brief, I think Mr. Thomas's mental health, his physical health, which has been deteriorating as a result of his mental health, his intellectual disability, and for all of those other reasons, this court should reduce Mr. Thomas's sentence in the interest of justice. Thank you.
Thank you both. Villani versus Kings Harbor. Counsel for Kings Harbor, Mr. Casino. Did
yes,
I say that right?
That is correct, Your Honor.
Okay.
It's not spelled.
You are up and you have 7 minutes, sir.
Yeah, Your Honor, I would just state at the outset, the appellant's counsel spoke, and we agreed that Mr. Bloom would be handling doing his presentation first, if that's okay with the court.
No, you go first because you're the appellant.
No, he's the co-appellant as well.
He cross-moved, correct?
I'm sorry?
He cross-moved?
You know what? I'll just go first then. That's fine. I apologize. I didn't want to overly complicate
Yeah,
it.
it's 7-2. So if he goes first, it just, then you have no rebuttal time. It's one straight argument.
Judge Manson,
I think
both, I think, didn't you give both of the appellants 7?
Yes.
Oh, okay. All right. I wasn't sure.
I have a David Bloom, a Scott Horn, and a Casino.
Yes. I'll just go first, Your Honor. I'm
Okay,
sorry. I didn't mean to overly complicate.
Okay.
Your Honor, the patient's amputations here were unavoidable due to his long-standing progressive end-stage renal, cardiac, and vascular issues. The plaintiff had 3 separate amputations, first of the 2nd through 3rd toe, then followed up by a transmetal amputation, followed by a below-the-knee amputation. The likely need for the further amputation secondary to his underlying disease was repeatedly considered and discussed by his treating physicians at Montefiore. Again, while the plaintiff was at Kings Harbor, he was under the care of the treating vascular surgeon, Dr. Parekha, who performed the amputations, and he continued to be seen by Dr. Parekha weekly at MMC while he was at Kings Harbor. I point this court, initially that there's several instances in my brief where I point out that this need for further amputations was considered by the treating physicians. There's a note on 32707 at Montefiore where it says this is after the after the initial amputation, but before the transmetatarsal amputation. The record says patient is currently on antibiotics and monitored closely for possible amputation of the right lower extremity in the future. Then following the transmetatarsal amputation, there's a notation in his record, again, while he's at Montefiore, it says, if no significant improvement in the near future, they should go on to perform a below-the-knee amputation. So the plaintiff is trying to say that the amputation that the patient underwent was somehow due to the care or the lack of care thereof that he was receiving while he was at Kings Harbor. However, our expert, Dr. Capobianco, established that these amputations are unavoidable due to vascular issues. There's no indication that any—
Counselor, this is Judge Singh. What you're saying generally, doesn't that just become a battle of the experts? Don't you have a stronger argument to be made here in this case?
Well, there's multiple claims here, Your Honor. This is the claim that we have regarding the amputations. When the plaintiff's expert is talking, our expert clearly set forth. So this is not a battle of the experts. I would respectfully submit. Our expert went forth and explained how these amputations were necessary because of vascular issues. The plaintiff's expert never even addresses the fact that the patient had all these underlying vascular issues. And there's numerous cases from this court which said that the defense, especially on the issue of proximate cause, that the plaintiff's expert has to address what the defendant's expert says in meeting its prima facie burden.
Did Dr. Clark have the appropriate credentials to testify, to give opinion testimony or opinion in his affidavit?
Well, I'm glad you brought that up because it's our position that he was completely unqualified. He never claims to have worked in a subacute or rehabilitation facility. He lays no foundation whatsoever regarding his personal knowledge in the field of family or geriatric medicine or anything in the setting of a long-term care facility. And he never claims to have treated or directed the treatment of a patient with numerous underlying comorbidities like the decedent had here. It is our position, that Dr. Clark has absolutely does not have the proper qualifications to render any sort of opinion.
So that goes to the malpractice, but there are other claims against you, correct? There's a negligence claim against you. There's a public health statutory claim against you too. How have you made out prima facies on those claims?
Well, with regard to, are you referring to the falls? I presume.
I'm referring to the falls. I apologize for not being specific.
No, that's fine. Well, we're referring to the falls. The decedent here, he had no cognitive issues. Well, first of all, I would say that there's no evidence that the decedent.
Well, there are 2 falls in this case, right?
Well, I would just say that there's no evidence first that of any injury, that he sustained any injuries as a result of these falls.
Wait a minute. It's your prima facie. In the first instance, how did you make out your prima facie? I understand you say there were no injuries, but how did you make out your prima facie that you properly monitored them, et cetera, et cetera?
Well, if you look at what Dr. Capobianco said, he basically said that all appropriate measures were being taken to protect the plaintiff from having falls. He was.
But he had 2 falls, so then how were all appropriate measures taken?
Well, Your Honor, one of the falls really was not a fall. It was really, he was found, I guess his blanket got stuck on his foot, and that's what caused him to then subsequently end up on the ground. But this was not a plaintiff that this was not a patient that required additional supervision. He didn't have any cognitive issues. And the plaintiff's expert, and there's anything wrong. The plaintiff's expert never identified anything wrong that was done that contributed to the falls. He makes vague claims regarding increased supervision, but never explains what this means or otherwise explains how the falls could have been.
Hadn't he just been transferred after having some toes removed?
Yes, Your Honor, but the fall had nothing to do with the fact that his toes were removed. I believe it was the first fall that you're talking about. Let me if you just bear with me for 1 second. Dr. Capobianco opined that all appropriate fall preventions had been implemented. There was a
Does he describe what those fall prevention methods that were implemented were?
Well,
or are we supposed to just accept that as a conclusory statement on his part?
No. He basically said that they provided a safe and secure clutter-free environment. There was PT and OT evaluations.
Was he provided monitoring? Maybe basic monitoring after the first time he fell, given, as my colleague pointed out, he was losing his extremities?
Well, at that point he had only lost 3 of his. Right.
Well, I don't know. I would think that the toes are pretty important for balance. I
agree, but there was nothing about this fall that indicated that the loss. And I agree with you on that point. But there's nothing about the fall, the way that these falls are alleged to have occurred, which has any indication that anything to do with the toes being removed.
But aren't these issues a fact? I mean, it seems that there's a bunch of issues of fact. I mean, you're saying that maybe it didn't have anything to do with it, but maybe it did have something to do with it. Just seems hard to determine this on the general comments of Dr. Capobianco as to everything was being done when he fell.
Also, I'd like to, I'm sorry, you could answer that question, but I'd like to follow up on the public health law.
No, sure. I would just say, Dr. Capobianco explained that there was nothing else that could have been done, but then which we submit shifts the burden to the plaintiff, and the plaintiff's expert doesn't really identify anything that should have been different. He refers to the fact that there was a book out there that said, we're taking an all-out attack on falls, and that's great. Yes, we're trying to prevent falls clearly, as any sort of facility would try to do. But just that doesn't equate.
So what did you do in this case? I'm sorry. What did you do in this case to prevent falls, or to not prevent them, but to monitor them so that this kind of stuff would not happen?
Well, again, Your Honor, Dr. Capobianco testified. That there was that he had a secure and clutter-free environment. And again, I would submit that.
Okay, I believe Judge Gish has a question.
Thank you. Right. So I just want to be clear. When we talk about the public health law, that's something different than ordinary negligence and medical malpractice, correct?
Yes, that's correct.
It's a separate basis of liability.
Yes.
And the court below didn't address that, correct?
Yes, Your Honor.
And I would think that it's fair to say that the reason that the court didn't address it is it wasn't really raised by you. It wasn't raised as a separate basis, correct?
That is correct. Yes, Your Honor. But
right. Even though you have a separate cause of action that's predicated just on the public health law, correct?
Yes, Your Honor.
All right. And so up on appeal, you do raise it, right?
Yes, Your Honor.
All right. And you raise it, and what you're saying is that it's an issue of law. We could just determine it as an issue of law. So we can determine it on appeal, right?
That is the argument, Your Honor, yes.
So, when looking at the statute and the basis for liability, explain to me why it would be just an issue of law when the predicate for proving liability under the public health law is different than ordinary negligence and medical malpractice, and it's subject to affirmative defenses by the providers that wasn't really fleshed out below.
Well, Your Honor, what I would say is that, the plaintiff has never identified any contract, statute, regulation, or code that conferred a right upon the decedent, which we deprived him of. At this point, he just has claims that the public health law was violated, but never specifically identified a statute that was violated or a contract or some sort of patient's bill of rights that was not complied with here.
But the record was never really developed below on that issue. It wasn't part of the motion.
I agree, but I still believe that the plaintiff would have had to have raised something below, even in the pleadings, identified some sort of specific statute. And absent that, I would submit that it's a purely legal issue that can be decided by this court as a matter of law, despite the fact it was unraised.
Okay.
Thank you.
Thank you.
Mr. Bloom, you have 7 minutes.
Thank you. Good afternoon, Your Honor. For the defendant appellant, Albert Einstein Jack D. Weiler Hospital, also known as Montefiore, we ask this court to reverse the order denying summary judgment, as well as the subsequent order which granted re-argument but adhered to the earlier decision, on the grounds that the plaintiff's expert, as it relates to Montefiore, was simply unqualified to render any opinions against this defendant. As it relates to Montefiore, this case involved a patient who was admitted to the hospital with life-threatening kidney failure. The plaintiff is claiming that the hospital failed to immediately address an ongoing GI bleed and that the dialysis was contraindicated during the GI bleed. So our position is that to that end, in order for any expert to comment on the applicable standards of care against the hospital, the expert should have some degree of background or experience in the treatment of dialysis patients, or at least some knowledge of nephrology. And here, Dr. Clark, the plaintiff's expert, simply did not have that. Dr. Clark is not a nephrologist, he's not a surgeon, he's not even a board-certified internist, as Judge Silver incorrectly noted initially. His background is exclusively in nuclear medicine, which frankly has nothing to do with dialysis treatment.
Counsel, why doesn't that go to weight as argued by or as found by Supreme Court?
It does not go to the weight because Dr. Clark's affirmations did not provide anything for the trier of fact to weigh. The only thing that they're relying on, that the plaintiff is relying on, is the completion of a first-year residency program in basic primary medicine, basic primary internal medicine. But that's not sufficient to qualify him as an expert. Internal medicine is a very broad area. There are a number of subspecialties that are recognized by the American Board of Internal Medicine. For example, cardiology, there's geriatrics, there's a host of subspecialties. But just because you had a residency 10 years before the alleged malpractice occurred, does not automatically render you qualified as
you can qualify by experience, right?
Yes, you do not.
So in other words, if an internist came in and gave a recount of his professional experience in dealing, let's say, with patients in renal failure, that would do it, wouldn't it?
I would submit that would be acceptable.
Or even in this case, because there seems to be a lot of issues raised about the way the GI bleed, or if there was a GI bleed, and if it was properly and timely investigated, and the order in which the dialysis occurred relative to the indication that there might be a GI bleed. A GI person, somebody with GI experience, could opine on that, right?
Perhaps, yes.
Right, but was there anything in any of the affidavits by the plaintiff's expert that indicated that there was such experience or such relevant experience?
I did not see any, Your Honor. I would submit that there's nothing in there other than a vague statement that he completed a one-year residency internship at, I believe, Stony Brook School of Medicine 10 years before the accident. That's just overly vague. It's conclusory. We don't know what that means. All right. Had he put in there something to the effect of, and I also am familiar, I've had experience treating dialysis patients, I've had experiences dealing with GI issues. It's just simply not in there. So as Your Honor correctly noted, you don't have to be a specialist in a particular field to opine on a particular case, but you do have to provide the necessary foundation. And here I'd submit that Dr. Clark did not do that. I would also submit that the plaintiff's reliance on the initial opposing affirmation by Dr. Clark, which was dated September 20th of 2017, that is undermined by the fact that the plaintiff improperly tried to bolster his expert's qualifications by submitting a supplemental affirmation for the first time in opposition to a re-argument motion.
But in that supplemental affidavit, he didn't raise any of the things as Judge Gish indicated. By the way, I want you to know I had all this additional experience that I omitted from my original affidavit.
That's absolutely correct, and I think that's quite telling. I mean, he gave himself, even first of all, he should not have been able to do that. But second of all, even if he gave himself the opportunity to explain his background, he did not mention anything about treatment of dialysis patients in an emergency setting, nothing about nephrology, nothing about GI. At best, he in the supplemental affirmation, Dr. Clark offered some additional information about generally the area of nuclear medicine, what that means, and what it takes to become a nuclear medicine doctor. But the fact that the plaintiff chose to throw in a supplemental affirmation, I think to me is quite telling and suggests that the initial affirmation was insufficient.
Thank you. You'll have time on rebuttal.
Okay.
Mr. Horn?
Good afternoon, Your Honors. May it please the court. Scott Horn, counsel representing the respondent in this matters. Based upon the court's questioning, I guess we should jump right into the question of the classification. And we submit, Your Honor, that Dr. Clark is clearly qualified to render opinions in this case based upon his training, experience, and expertise in internal medicine, as well as his background treating patients in hospital and acute care settings. Now, the fact that
does he describe, sorry.
Go ahead.
Does he describe that care? Because clearly the 1 year residency is kind of light. So I'm looking more toward what does he give me in terms of actual experience to kind of buffer what's missing in the credentials. Could you point to me what specifically he talks about rather than just in general, I worked at the VA for some time?
Yes, Your Honor.
I mean, specifics.
Sure. So the following page, so he references the residency at the VA and at Stony Brook in internal medicine at page 3075 of the record. And then on page 3076, he makes specific reference to, and I'm referring to Roman numeral 4 in paragraph 3, my own training, experience, and expertise in the field of external medicine. And then number 5, my own background in dealing with patients in a hospital and acute care setting. So I think that when we look at the facts in this case, I think it's important to consider the doctors that we're talking about who are culpable and the nature of the claims of malpractice. Now, both Dr. Ross himself is an internist. Dr. Potenza, who is also a treating physician at the center of this whole controversy, is also an internist. Dr. Ross actually did a residency himself in internal medicine.
But he's not an internist.
Excuse me, Your Honor?
He's not an internist, though.
Dr. Ross was essentially the attending physician for the rehabilitation facility. His background was, and he testifies at page 2948, was that he did a residency in internal medicine. And so that's exactly
but based on, I mean, his experience, he's working here for extended period of time in a rehab center, and like Kings Harbor, where you have people with all kinds of acute and different kinds of injuries than just an internal medicine doctor may be faced with under other circumstances.
Understood, Your Honor, but that's why the experience that's listed here on 3076 about dealing with patients in hospital and acute care settings becomes pertinent. And again,
so
I think
why don't we go on to the actual substance of of his affidavit and how the doctor addresses or fails to address the opinions of defendants' doctors.
Yes, Your Honor. So as far as the actual departures, there are no less than 13 different departures that are outlined by Dr. Clark. 7 of them are geared towards Kings Harbor, and 6 of them are geared towards Montefiore. These departures are the exact type of departures you would expect from an internist. For example, the first departure, failure to prescribe antibiotics between April 19th and April 28th. This is an extremely specific allegation of departure and malpractice. And this is exactly the type of opinion that you would expect an internist, someone with a background in internal medicine in a hospital.
Does he opine what the doctors should have prescribed during that time and in what dose?
Well, he does say that they should have prescribed antibiotics during that time period, and that would have prevented the foot amputation, which is at page 3079 of the record. He also specifically opines that—
Wait a minute, wait. This is a patient who had already had a number of partial amputations of metatarsals, correct?
That's correct. He had 3
So
toes.
already his body was in that process. He was a diabetic. He was in renal failure. He had vascular disease. I mean, he had a multitude of comorbidities that impacted each other. And I don't recall that the affidavit specifically addresses some of the treatments and that both King Harbor and Montefiore employed in attempting to deal with this confluence of all these comorbidities.
Right. Father Villani had already undergone 3-toe amputation by the time he got to Kings Harbor during the germane time period. The failure to prescribe antibiotics, in particular, the very first departure, is linked by date and by the subsequent loss of the rest of his toes and part of his foot, which is referred to as a foot amputation. Okay, and that's at page 3079 at the record. In addition to that, there are specific references to a MRSA infection that had been allowed to proceed unabated for 40 days. From June 26 to 8/5. That's at page 3080 of the record. It's as a direct consequence of failing to treat the MRSA infection for 40 days.
But they were treating it. They were treating the infection. It wasn't resolving in the way that they had hoped, but they were treating. They kept on debriding him, checking his wound, etc. And when indicated, he was taken to the hospital.
Debriding and cutting away flesh is, with all due respect, not treating a MRSA infection. A MRSA infection that's allowed to go unbaited ultimately results in this sort of gangrenous and sepsis that ultimately required an amputation below his knee. And that's at page 3080 of the record. And it's a direct causal link from one to the other. And this is, again, precise.
This is Judge Gish. Would your doctor have had to address the fact that the defendant's doctor indicated that situation erupted because of his vascular disease? Did your expert address the vascular disease and why it was a rule out?
I would say 2 things in answering that question. Number one, the proximate cause analysis that was offered by the Kings Harbor expert was manifestly conclusory in nature. In a sweeping fashion, he said that any malpractice that was committed, ultimately, there's no causal connection to all these amputations because of the pre-existing vascular disease. He didn't talk about the lack of prescribing antibiotics. He didn't talk about the untreated MRSA infection. He didn't talk about the way that there was no physical examination of the wound site, none of it. And so we submit initially, Your Honor, in response to your question, that they did not meet their prima facie burden on proximate causation because it was a sweeping conclusory and one-sentence statement in the affirmation. With regard to what my expert said, Dr. Clark, he specifically said that regardless of what the past history was, it was the treatment that was rendered at Kings Harbor that led to these multiple amputations. He specifically said the failure to prescribe antibiotics, the untreated MRSA infection, the failure to monitor and examine the actual amputation site underneath the bandages, the failure to do any of that specifically related to the subsequent amputations. And even if you assume that they met their prima facie burden and that vascular disease cuts off all causal nexus, because it certainly doesn't give carte blanche for every act of malpractice that you can imagine committing, right? What about the GI-related acts of malpractice that are specified by Dr. Clark? So he also talks about how they should have never prescribed Coumadin, which resulted ultimately in a gastrointestinal bleed that ultimately put him into cardiac arrest and ultimately palliative care before his death.
Doesn't the record reflect that Coumadin had been started prior to his arrival at Kings Harbor, and he had been treated with that for some time prior to his admission at the facility?
Many years earlier, there had been a decision made not to treat him with Coumadin. I think it was about 7 years earlier, and he was treated with folic acid. And the decision to treat him with Coumadin occurred after he had, in fact, I believe it occurred twice after he had come to Kings Harbor. Once it resulted in a dramatic spike up to something like 7.5. And the second time was immediately before the dialysis, which put him into cardiac arrest. So we submit that the prescribing of Coumadin and then the failure to monitor the INR rate and the TARI stools immediately before he went into cardiac arrest, these are two other acts of malpractice specifically identified by Dr. Clark that led directly to what we saw happen when he was given the dialysis, which allows me to now transition into Montefiore. So with Montefiore,
Counselor, I apologize.
Go ahead, Judge Singh.
But could you address the 280-01 claim as well as the negligence claim with respect to the rehab center?
Well, sure. The 280 claim, the public health claim, Your Honor, is absolutely correct in saying that there was no argument for summary judgment on that ground. As a consequence, the prima facie burden was not met and the burden of proof did not shift to the plaintiff in the lower court. With regard to the preservation argument, clearly that's not a legal issue, it's fact dependent. And if the issue had been raised, the factual information, evidence, and arguments could have been raised in opposition, right? So we talk about now counsel saying, well, it's a legal argument and plaintiff never put anything in factually to meet the standard. And so that in and of itself shows that this is not a purely legal argument and that ultimately, had the burden been met, it would have been incumbent upon plaintiff to come forward with the necessary evidence. So with regard to the falls, I think there's a tremendous amount of evidence in the form of Dr. Clark's testimony, as well as, his opinion in his affirmation, as well as the affirmation of the registered nurse as well, Posinski, which talk about how they, despite the fact that he's put there with toes missing and is a fall risk, that they had failed to put in place the necessary parameters and things in place to prevent him from falling. So again, I think that at the end of the day, when you're looking at those items with regard to Kings Harbor, the court understood that this is a classic battle of the experts. The qualification issue is frankly, I believe, a non-starter in light of the fact that these are all internists and they all have a background in hospital and acute care settings. So I think that ultimately you get to a battle of the experts. And
thank you so much. We're out of time, Mr. Horn. Thank you.
Thank you, Your Honors.
Mr. Casino, you have 2 minutes.
Yes, Your Honor, I'll be brief. I would just say, as far as what the plaintiff's attorney is saying about that these were not vascular, and he's saying his expert didn't have to address the fact, or was able to basically raise an issue of fact. I would just say that when you read Dr. Clark's affirmation, he never mentions the word vascular. It's not there at all. So he completely disregards the vascular nature of these injuries. Just with regard to the presumed GI bleed, the plaintiff's expert it's undisputed that the plaintiff was required anticoagulants because he was an increased risk for deep vein thrombosis because of the below the knee amputation. Although the plaintiff's expert talks about that there should have been alternative anticoagulants, he never explains how another unnamed anticoagulant would have been effective in reducing the risk of blood clots while not raising the INR and a risk of a bleed. We had no choice. I mean, he needed these things. These medications, increase the risk of bleeds, but they also prevent a potentially fatal, deep vein thrombosis. I would just point out with regard to the public health law claims, the plaintiff's BP and the verified BP, the plaintiff's BP is at 2670 of the record. The verified BP is at 103 to 115 of the record. They never identify a specific provision of the public health law claims. I think that's something that I would ask that this court take that.
I don't understand that argument. Yes. How are they supposed to anticipate what they should do if you haven't raised it down below? I don't understand.
But Your Honor, we're also then, if we're moving for summary judgment, there's the public health law, the 2801, it's dependent on establishing a violation of a regulation.
Yeah, this is Judge Kish. There's a whole list of things that are alternatives that can provide the basis. Statutory violations are in fact one, but it's not exclusive. And my understanding is that falls and bed sores typically come under the public health law, that you can find a section that would come with under. So I'm having trouble with your argument. They didn't identify. It just wasn't up for consideration.
Your Honor, I agree with you. What typically happens in a lot of these cases with falls and bed sores is that the plaintiff will identify 30 different public health laws, 30 different regulations that were violated. And it doesn't have to come from a statute. It could come from a contract. Sometimes there's a patient's bill of rights. And what happens is in the bill of particulars, the plaintiff will identify the specific right that they were deprived of, be it in a statute, be it in a regulation. It's similar to, analogous, I guess, to like a 241.
I'm not disagreeing with that, which is why maybe you should have moved for that.
I understand, but if the plaintiff isn't raising anything, then there's nothing really for us.
You are the movement, Mr. Casino. You are the movement.
Your Honor, I completely appreciate that. The point I'm trying to make.
We've gone through this in circles, and I think we've got the issue. Mr. Bloom, you have 2 minutes.
Yes, thank you, Your Honor. I just want to point out that the portions of the record which Mr. Horn cited during his presentation where he discusses Dr. Clark's credentials or lack thereof, those portions of the record dealt with the affirmation that Dr. Clark submitted in opposition to Kings Harbor. All right, none of that was put into the affirmation in opposition to Montefiore's summary judgment motion. I would also want to point out that
although he's the same person, I mean, whatever experience he had.
Well, I understand that, but there's nothing for the trier of fact, whether it be the court or the jury, to understand what it means when he says that he has years of experience in basic primary internal medicine.
That's a different issue. Whether that would really qualify to otherwise explain what the relevant experience is. A generalized statement may not do it, but the fact that the affidavit and motions that were considered together was appropriate, particularized in one, but not the other. I think that's a harder argument for you to make.
Well, I would also point out that when we're going back to the supplemental affirmation, again, he didn't put in a supplemental affirmation in response to Kings Harbor's motion, but he did with regard to Montefiore. And in that supplemental one, again, he uses the phrases, years of experience in primary internal medicine. He has participated in the coordinating of care in long-term care and nursing home patients. That may arguably that may be relevant to Kings Harbor, but it's not relevant to the dialysis treatment that was rendered at Montefiore. And in fact, the supplemental affirmation doesn't say anything about dialysis or treatment of patients who have kidney failure. he tries to bolster his credentials by saying that the Workers' Comp Board recognizes him as an authorized general practice physician. What does that mean? I would submit that this is not a matter of the weight of the evidence, because there was nothing for the trier of fact to weigh. Lastly, I think I'm running out of time, but to the extent that Dr. Clark was qualified, his opinions were conclusory, they were speculative, for all the reasons I've stated in my brief. Dr. Clark did not address specific portions of the record, did not address the points raised by Dr. Goldfarb in support of Montefiore's summary judgment. And I would submit that that's insufficient to raise a triable issue of fact.
Thank you so much.
Thank you.
This court now stands adjourned.
Thank you.
Thank you.
Okay.